Hey everyone, welcome to my case summary of the Supreme Court's decision in Mullane versus Central Hanover Bank and Trust Co. The decision from 1950 by Associate Justice Robert Jackson, and it's all about notice in a lawsuit, constitutional notice. So, to sue a defendant in court, you need to give them proper notice that they are actually on the hook, that they are going to be taken to court. And Mullane addressed this. It addressed how notice must comply with due process. And so I feel like in a lot of textbooks, it's really long and convoluted, the fact pattern, but it's not really so. It's just a really long opinion. But I'm going to break it down and make it nice and short and easy to understand. So Central Hanover established a common trust fund aggregating 113 small trusts totaling $3 million with 5,000 beneficiaries. Following New York state law, the bank sought judicial settlement of accounts adjudicating interests of the trust beneficiaries. The bank gave notice by publication in newspaper and mail as prescribed by state law. So Mullane and Vaughn were appointed to represent beneficiaries' interests, but their notice objections were overruled. So think of Central Hanover as the plaintiff and the beneficiaries as the defendant, and Mullane and Vaughn represent the defendant's interests. So in that sense, they are the defendant. So they lost in the lower court. That's why Mullane comes first as the petitioner at the Supreme Court, trying to get the Supreme Court to agree that the lower court was wrong. And so what does the Supreme Court say? Was the lower court wrong? Yes, the lower court was wrong. Central Hanover's notice to unknown beneficiaries was proper because it was practically difficult to give them notice, but their notice to known beneficiaries was not proper because they could mail them notice. Notice must be reasonably calculated to reach the person that you're trying to put on notice. So there's kind of a case-by-case analysis of how this works. You can do a lot of things for notice. Obviously, one form of notice for one person that's valid might not be valid for another person. That's what was the case here. The unknown beneficiaries are just harder to give individual notice than are the known beneficiaries, Mullane and Vaughn, representing those beneficiaries at least. So, you evaluate it on a case-by-case basis. There are some cases where, for example, people have used Facebook Messenger to give notice. Social media, a lot of things in this digital age can be used for notice. The key for due process purposes under the 14th Amendment is just that it's reasonably calculated to reaching the defendant and putting them on notice. So yeah, that about wraps up the summary of this case. What it stands for is pretty straightforward. It will likely appear in a civil procedure course. It's good to know in general too. So if you're an attorney and you like this, I'm very happy that you like it. If you found this video interesting, insightful, or helpful, please leave a like, comment, or subscribe. I want to get you to an A++ on your civil procedure exam, and I'm going to do that. But yeah, thank you so much for watching, and I look forward to speaking to you in the next video.